From the opinion pages of the Wall Street Journal, this is Potomac Watch.
A leak of correspondence between Hunter Biden's defense attorneys and now special counsel David Weiss shows the depth of political taint in the case against the president's son. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Kim Strassel and Bill McGurn. Let's start with some analysis of this incredible leak to the media. There's a story in the New York Times, another story in Politico, apparently hundreds of pages of correspondence between Hunter Biden's defense team and the now special counsel David Weiss, who at the time was the U.S. attorney in Delaware when this investigation was taking place. Kim, what do you make of this? And what did we learn from the correspondence, at least what's being reported about it, about the negotiations between Biden's team and the prosecutors?
Yeah, we've learned, in my mind, two really important things. And of course, the backdrop for this, remember, is we've had these IRS whistleblowers come forward and claim that there were shenanigans during the investigation, that the team had wanted to charge Hunter with felonies, but in the end, they were sort of kicked off and stymied in their investigation, and that was then reduced to a kind of misdemeanor and gun deal that ultimately fell apart, went in front of a judge. But here's what we learned here. The first was that there was a full court press by Hunter Biden's legal team, including his lead lawyer at the time, Chris Clark, to pressure the Department of Justice to not bring any charges at all. One of the things that was produced was takes of a 32-page letter that Chris Clark sent to now special counsel David Weiss in the end of October of last year. He complained that a recent leak in the media suggesting that the government had enough evidence to charge Hunter, that leak had been illegal. But then he also made a threat. He claimed that if the Justice Department charged the president's son, that his lawyers would demand that the president go on the witness stand. And, quote, this is from his letter, President Biden now unquestionably would be a fact witness for the defense in any criminal trial. He also wrote, this of all cases justifies neither the spectacle of a sitting president testifying at a criminal trial, nor the potential for a resulting constitutional crisis. So there was that threat out there. But I think the other more important thing that we learned is that David Weiss's office seemed to go for a while or capitulate to this, and that we find out that one of Weiss's deputies in the spring of this year, in the lead up to an actual announcement of charges, initially floated a deal in which Hunter would not, in fact, be charged with anything, that all he would be hit with was a deferred prosecution agreement over this gun charge. She appeared, this is Leslie Wolf. She was also central. The IRS whistleblowers claim that she was one of the people that really stymied certain leads in the investigation. But she also now looks to be the architect of an initial deal in which Hunter essentially would have gone scot-free. And only after the IRS whistleblowers came out with their testimony did Weiss's office change its mind and then demand that Hunter face misdemeanor charges.
Part of the full court press by Hunter Biden's defense team was also requests by his attorney to top officials at the Justice Department that they meet with him. And they included requests to the head of the criminal division, the head of the tax division, the Office of Legal Counsel, the Office of the Solicitor General, Deputy Attorney General, and the Attorney General himself. And the Politico story says that most of those requests went unheeded. But eventually, the defense attorney, Chris Clark, was able to get an April 26th meeting with himself, David Weiss, the U.S. attorney, and Associate Deputy Attorney General Bradley Weinsheimer. And this is remarkable. I mean, imagine you are the U.S. attorney in Delaware, a relatively small backwater office. You get this politically charged case. And then you have the defense attorney saying, not only will he call the president to the stand if you take the president's son to trial, he's emailing around the Justice Department, getting meetings with people who are above you in the chain of command. And it would take some real guts, Bill, to stand up to that kind of pressure. And so your column this week is under the headline, David Weiss should resign. Give us a sense of the argument that you're making.
Well, it's two. This illustrates the flap over Joe Biden testifying. Look, we know that Hunter invoked his father to Henry Zhao, Chinese businessman, Communist Party official, that Hunter thought he was owed money from, and he threatened to use his father to punish the guy. So now that's apparently not the only use of a brand of Joe Biden. His lawyers use it. What you're saying actually is that they threatened to put DOJ lawyer's boss on the stand to embarrass him. And these guys are all concerned about their careers. So it's a very intimidating move. I think they put it this way. Chris Clark said would force a constitutional crisis. And in other words, we're going to force a constitutional crisis to get Hunter off. That's real hardball. It's not unexpected because they were trashing witnesses against Hunter before. All along, they played hardball. And David Weiss looks weaker and weaker. It's unclear whether he tried to do a reasonable job and found himself thwarted by these officials at DOJ. If that were the case, the decent thing to do would be to resign and then say why he resigned. But he didn't do that. The decent thing is not to stand by and let them get their way. It's to explain to the American people why. So it's such a mess. And to bring in David Weiss now as special counsel against all the department rules, which call for an outside prosecutor, is just a brazen move, and it will only undermine confidence in this prosecution.
Well, let's talk about a couple of those arguments because they're circulating in the public debate. One of them that Bill alludes to is you're hearing a lot of arguments that Republicans were calling for David Weiss to be named a special counsel, and now that he has been named a special counsel, they're criticizing him. But Kim, to my mind, there's nothing really conflicting about that because the point of calling for him to be a special counsel was to give the kind of independence. I know we don't think special counsels are really independent, but give a little bit of cushion and breathing room to David Weiss as he was going about these negotiations, which we now see how they were playing out in real time there via these document leaks. But now we have a flip situation where we have this fiasco of a plea deal that was first negotiated and would have required Hunter Biden not to plead guilty to anything. Then after the whistleblowers came out, it was strengthened and they were going to require Hunter Biden to plead guilty to tax misdemeanors. And then that plea deal was structured in such a way with this broad immunity that it fell apart on first questioning by a federal judge. So I don't think there's any conflict, Kim, in criticizing now the idea that now you're going to make Weiss a special counsel because he's the guy who was in the middle of the fiasco in the first place.
That's absolutely correct. This is no longer just a story about Hunter Biden's misdeeds. It's a story about the U.S. attorney's handling of this investigation. The accusations that it was initially mishandled, that political pressures came to bear by Leslie Wolf and others who stopped IRS and FBI agents from pursuing leads that they thought were valuable because it might bring them closer to President Biden. It's about that initial deal that you mentioned, which seemed to be in response to perhaps threats from Hunter Biden's legal team. It's about this whole fiasco as well that played out in the courtroom, in which it would appear that David Weiss's team suggested, at least in a wink nod deal to Hunter Biden's team, that there would be an immunity clause that walled him off from any further prosecution. But then when questioned, they reversed themselves in court, which caused the deal to fall apart. It's about the question, by the way, too, just because David Weiss is special counsel now, it does not answer the question, the all-important question of whether or not he was denied that authority in the past and whether or not he was blocked from pursuing charges by Biden appointee attorneys in Washington, D.C. and California. So all of that is now in play. And putting the guy who's in the middle of all of this in charge of a situation that nobody has any faith in anymore was absolutely the wrong way to go about this. So, I'm with Bill. I don't really like special counsels, but if there was truly a need to have one here, this is not the guy who should have got the position.
The other argument you raised, Bill, is that the regulations say a special counsel should be from outside the government. And it's true that that can be waived when the special counsel is appointed. But taking the special counsel idea on its own terms. The idea is if the Justice Department has a conflict and you're going to appoint a prosecutor and give him some special authority to take care of that conflict, it makes sense to get somebody who is not inside the Justice Department at the time. And the counter argument you're hearing in the debate is, well, what about John Durham? John Durham was appointed a special counsel to look into the FBI's investigation of President Trump during the 2016 campaign. And before taking that job, he was the U.S. attorney in Connecticut. But again, I don't think that's responsive, Bill, to the real argument here, because John Durham was not at the FBI when this stuff was happening. And to the point that Kim is making, this is not merely a story about what Hunter Biden did. It's also a story about how this case has played out and whether the government was doing impartial justice along the way.
Yeah, let's take John Durham. When he was assigned the case to look into the FBI investigation, it was the Trump administration, right? There was no conflict of interest. The special counsel comes when there's a conflict of interest, usually involving the federal government investigating itself, or someone very sensitive high up on the president's staff or something. And there's a feeling that the conflict of interest will prevent justice from doing a thorough investigation. So when he first appointed, he didn't need that. There was no conflict of interest and he could proceed. Then he was appointed kind of in the waning days when the Biden administration was coming in, and there would be a conflict of interest if the FBI were helping the Biden administration. As for David Weiss, the same thing. You could argue that, again, like him, I'm skeptical about special counsels. I don't think we should rely on them. But by their rules, there was a case where Barr might have appointed David Weiss, might have elevated him to special counsel once the Biden administration was coming in. But the problem is, Kim said, now this question, the IRS agents raised these issues that they were obstructed in their investigation. They had searches thwarted by DOJ lawyers. They had interviews, kind of obstacles raised to interviews. They weren't allowed to ask about the big guy or the president. A lot of things to hamstring them when they were doing it. And they've talked about this, and they said David Weiss told them he asked for special counsel status and was denied. Now, we don't know what happened, but that's a question. There's obstruction. And David Weiss was either part of that obstruction or is a fact witness to it. He can't be involved in an investigation where, at the minimum, he is a fact witness to it. That's why I say this appointment only sows confusion and greater distrust about the government.